let's go to the instruction on manslaughter. Okay, I'm going to find the defense. Here's your instructions.
So are you there, Judge?
I'm right here. Okay.
Actually, I was going to propose, if it's the same to you, to start with vessel homicide, since manslaughter is supposed to be the instruction that has additional burdens on the state. So we can first understand what vessel homicide means, and then the court would decide what additional burdens the state has to meet to go to manslaughter from vessel homicide. So that's
Okay. I hear what you're saying. I'm okay though, starting with the manslaughter. I'm just going through the elements that need to be established. And because you have, in the manslaughter, you have, and I understand why, you have included additional language that, in terms of definitional type of language, that you're going to ask me to instruct the jury on, that are not part of the standard instruction.
That's right.
And the reason why I'm going to make an assumption is because there has to be more that needs to be shown in terms of culpability. It's a greater amount of evidence in terms of culpability. Culpable negligence is a greater burden, and in describing that, you don't have the same explanations provided in the vessel homicide.
So that's in theory correct, although, as I've indicated throughout the proceedings, there's, in my view, tremendous confusion, indeed vagueness, associated with these two different charges. I understand the Supreme Court of Florida in a case called McCreary, and then a subsequent case over dissenting justices' opinions. There's this, I would say, at a minimum, confusion over the differences. If nothing else, it's hopelessly vague, but we'll get to that. And so, yes, I agree with you with that caveat. It seems to me that, well, I guess we should start and then we'll go through manslaughter.
Let's work through it, okay?
So there is one issue I'd like to flag for you. So manslaughter apparently has multiple ways of prosecuting it. The statute itself, we can just pull it up. So we've been talking a lot throughout the trial about culpable negligence as one way to establish manslaughter.
Okay, so let's look at 7.7 under the standard instructions. Let's go ahead and look at that, okay?
Are you looking at 7.7 in the pattern?
Yes.
Okay.
2026 standard instructions. And if you notice there's some language there that it's fundamental error not to construct unjustifiable and excusable homicide in the absence of an express concession that the homicide was not excusable or justified.
That sounds to me like it can be waived, so that it's not required to be given.
Express concession, how I interpret that, right? Does the state have an objection to my excising out the portion of the instruction that I really think is raises unnecessary points that are not applicable in this case?
No, I don't mind.
Okay. So,
But I would object to not including excusable homicide.
sorry?
I would object to not including excusable homicide.
Right, I'm
But if the
justifiable.
defense is affirmatively saying they do not want justifiable use of deadly force to be instructed, then, okay, that's fine with me.
Okay, so I consider that a sufficient express concession by both parties on that,
On justifiable use, yes.
unjustifiable. Okay, so,
Is the defense,
You agree on justifiable?
Yes, I agree on justifiable homicide.
okay, good.
and beyond that, because the defendant is not here,
I'm gonna have to readdress this with Mr. Pino present before I'll put everything in kind of the best final form, and we're gonna convene, I think probably 9:30 on Monday, and 9:45 even. I think, having that express concession. I'm gonna have duplicates prepared for either way, just because I'm neurotic like that. So in the event that Mr. Pino doesn't agree, then I have the instructions completed. I'd like to have them completed, and we're going to complete our charge conference today, is my plan, all right? Whatever is outstanding, throughout the course of the weekend, you'll hear from me, and I'm going to have prepared what I consider to be the final instructions. I'll put anything else on the record, and so they should be available to you as you're giving your closing argument. The state's going to start, and I guess you'll reserve time for a rebuttal argument anyway.
I'm just wondering if it's possible that the defendant could at least join us by Zoom or something so that the defense can consult with their client. These are really fundamental issues that might be a little bit boring for people that aren't in law, but this is the crux of the case. I don't understand what he's doing. I think the court excused him. I didn't realize the court had done that, which of course is within Your Honor's discretion, but...
Well, I don't think there would be, well...
I mean, this is absolutely a fundamental part of the proceeding.
No, it is absolutely a fundamental part of the proceeding, because I have to get his acknowledgement, and I guess I'm comfortable that I'm going to get an acknowledgement and agreement Monday morning.
I can tell you, I'm certain that Mr. Pino is going to rely on our advice on these issues, without a doubt.
Okay.
And if you'd like, Judge, today we can actually have him submit something in writing before Monday, if that would be helpful.
The problem is, Judge, that I'm quite confident that this defendant's attorneys have told him on multiple occasions to stop emoting during this trial, and he hasn't.
I'm sorry, I didn't hear you.
To stop emoting, to stop with the head nods and the head shakes and the gestures and all of that, and he has not stopped. So I know his attorneys are operating in good faith, but I don't know what to expect from this defendant on Monday.
Okay. Once we get to the conclusion of this charge conference, before I sign off, you can summon via Zoom your client,
Sure.
and at least I would get something verbal as far as that's concerned, and then I'll follow up with it in person on Monday. Okay? All right. So let's get through the manslaughter charge.
Guys?
Number one, the two elements must be proven is the victim is dead. So Luciana Cristina Fernandez is dead. And number two, give as applicable. So there's several subparts. A, defendant intentionally committed an act or acts that caused the death of the victim. Now, you've taken that out.
Yes.
Okay.
We believe this case is about culpable negligence. That's the third prong, C. Charlie prong.
Okay,
And so A and B are not at issue in the case.
okay.
Judge, the information in count 1 alleges that the defendant did intentionally commit an act or acts and/or acted with culpable negligence. So that's why both prongs should be given to the jury. The court did not JOA on either prong.
I didn't.
No.
Okay.
So let me begin by renewing then on the A prong of manslaughter. And then we're going to, if the court is overruling that, then we're going to have to spend some time understanding the difference between the two because it's going to be complicated. But first, my motion is to judge judgment of acquittal on the A prong, intentionally committed an act or acts that caused the death of Lucy.
Which is what I heard yesterday, I think. That was part of...
That was part of it. And Your Honor had asked some provocative questions about that. And,
Oh, thank you. Okay.
well, many of your questions are provocative, but on that subject, it caught our attention because what is the act, what is the difference between A and C? Let's ask the question that way. You would ask the question,
I mean, I think I understood our conversations and what I based, my ruling on. I denied the judgment of acquittal. The state charged this in the alternative, right? And or it could be either. So manslaughter could be in their charging document. If they're able to prove manslaughter either by Mr. Pino intentionally committing an act or acts that caused the death of Ms. Fernandez, and or the death of Ms. Fernandez was caused by the culpable negligence of Mr. Pino.
right?
Right. And so your question was, and part of the argument was, what is the act or acts, well, that caused the death? The defense position is hitting the marker was the act that caused the death.
Correct.
Okay.
Because absent the elision, there's no death.
Okay. Understand. And I'm not going to speak for the state, so I think I understood their argument was the act leading to the elision are the intentional acts that lead to the death, such as, Ms. Adams, I think you said, the change of course.
Right, we already litigated that, but yes.
Okay, so, and that's what the state argued would be the intentional act or acts that ultimately caused, that caused the death of Ms. Fernandez. Does that make sense?
Except that the change of course didn't cause the death. It was the elision that caused the death. I understood change of course is the culpable negligence, is putting it on a path towards an elision. It's not, it doesn't cause the death. So at the moment that he changed course, nobody died.
I can't charge the water with causing her death.
That what?
I can't charge the water with causing her death. I mean, we already litigated this. These are what are in the charging document. The court denied the JOA. This is an accurate statement of the law.
So let's go down that rabbit trail. What is the jury under 2A, the act or acts that caused the death? The state is saying now it's enough that he changed course.
I'm not saying that.
Okay, I'm not sure what then the act is that caused the death if it's not the elision. Because typically culpable negligence is the whole course of conduct that puts the passengers in peril, is what typically happens in culpable negligence, driving in a completely erratic way beyond the pale, and something happens, but it was not, it was no intention to crash in a culpable negligence case. If he intended to crash, if the driver intends to crash into the pole, if Mr. Pino intended to crash, let's say that a driver says, I think the Robalo can handle it. I'm going to hit the pole and prove that the Robalo is just as good as a Grady White, that other boat brand. What is the crime? He didn't intend to kill anyone. He thought it was going to survive the crash. He's guilty of culpable negligence if the state proves he's acting with such depravity that even though he doesn't intend to kill someone, that act of elision causes the death.
Doesn't it go to whether something is foreseeable given the conduct?
It would be foreseeable that someone could die if you allied with a marker at 47 miles per hour. So if the person intentionally allied with the marker at 47 miles an hour, that would be manslaughter. It could be murder if it was his intention to kill everybody. If it was suicidal and homicidal, that was his intention. The state's not contending that. There's no evidence of that he intended to kill anyone. The state may be contending, I thought they were contending he wasn't intending to hit the marker at all. That's what they've said before in this courtroom. So if he was not intending to hit the marker, and he was simply intending to go back to Ocean Reef, but because of his failure to act with sufficient care, he was reckless in the way he operated, he accidentally hit the marker, accidentally meaning he didn't intend to, then he's perhaps, that's where the state is pursuing subsection C as a theory of manslaughter. That's how I view the difference between A and C. A was an intention to strike the marker, although without intention to kill. C is no intention to hit the marker, but driving in such a reckless, forgive me for using that word, culpably negligent manner that it was predictable if you drive blindfolded while drunk at a high speed, you're going to hit something, even if you don't intend to. The best example that I could come up with in my mind in a car, somebody's running away from the police at 90 miles an hour down the interstate. He doesn't want to crash. He's trying to get away. But you go 90 miles down the interstate in the opposite lane through traffic, there's a high probability you're going to crash and kill someone, even though that's not your intent. That's culpable negligence at a minimum, perhaps.
Well, if you, in your driving example, if you're driving on the wrong side of the road, okay, it's foreseeable, reasonably foreseeable, that someone's going to come up on the other side.
Right, and that's culpable negligence.
Okay.
That's different than
But you don't need to be driving at 80 miles an hour to do that, or, you know, weaving or...
You may be right about just how reckless one has to be, but in either scenario, it was not the driver's intention to have a crash. It was his intention to avoid.
Is it reasonably foreseeable that a crash would result if you stay on the left side of the road instead of the right side of the road?
It could be, but that would be culpable negligence, not under A, an intentional act that causes the death.
Okay.
The causation of the death is the impact.
Okay.
Driving on the wrong side of the road may or may not result in a crash, depending on who's there.
Okay.
So that's
it's your position, the only applicable subsection would be C.
That's right.
Okay.
Well,
And
reserving my objection, of course, that they haven't proven even that.
Okay.
But A appears not to even be the theory of the state that he was trying to hit the marker.
okay. Now, understanding it's charged, and I'm going to run back to the state on this. Oftentimes, you know, charged in the alternative, it seems that that's how it's charged. So, in terms of the evidence for intentionally committed an act or acts that caused the death of Ms. Fernandez. And one more time for me, the acts that caused the death beyond the actual impact.
Can I just incorporate the arguments that I made during both of the JOAs? I've already said them multiple times. The court has denied the JOA. The court has already found as a matter of law that the state has proven enough for it to go to the jury.
Right. In your argument, and again, defense finds distinguishing, and there's no way, apparently, from the defense argument to distinguish. It was established X, Y, and Z under subsection A, or alternatively, how they've established under culpable negligence that it's a manslaughter. That's what they're going to argue. And you're going to argue there's no application at all, and there's no culpable negligence. I think that's how it's going to work out.
Except that, yes, except that there needs to be some understanding of what the word act is under A, that if as a matter of law the act doesn't cause death.
Well, here's the thing. If there was some requirement, at least from a legal perspective, from the court's requirement of how to instruct the jury on the law, okay, there'd be a definition, right? And there's no definition here, there's nothing provided by defining what the act is. What the act is. Okay?
It has to be that which caused the death.
Okay.
Under A, the act has to have caused the death. That's the definition.
Right.
And so, maybe we should, if we move
How
down.
about this? If Mr. Pino, from the evidence, didn't change course, would there have been an elision? No.
You're saying at the 9-second mark, if he had stayed on the path before the 9-second mark?
I think before that, wasn't it? Wasn't there a change of course at like 30 something seconds?
I think the state's theory is that at about 9 seconds to impact, there was a change of course that put him on a collision course. That's the state's theory.
So that's the question, right? That's my question. If there was no change of course,
At 9 seconds, he would have
there would be
avoided.
no elision.
That's correct.
Okay, so I suspect what's going to be argued is that the act itself of changing course resulted in the elision.
Except,
Okay, we're gonna keep going back and forth on that. I certainly get your point. Over objection, I'm going to give subpart 2A and subpart, which would be C, but I'm going to call it B, because subpart B here does not apply. Okay?
We
But
agree
your
that-
objection is
we agree that B doesn't apply, preserving the objection is.
absolutely. Okay. Go to the next paragraph. Okay, I don't see any conflicts in what you've provided. Then the paragraph that starts with to convict of manslaughter. I think I would be taking out, let's see, I'd be taking out justifiable, okay?
Yes.
We agree to that, but here's where the conflict then arises
Okay.
with excusable homicide.
Okay. It says not merely negligent. So it's already in there. If Mr. Pino, if the jury finds Mr. Pino was merely negligent, then they can't convict him of manslaughter.
That should end it.
Okay.
There should not be the confusion about excusable homicide.
Okay. And that is consistent with the argument you've already made about excising out excusable harm, essentially not giving the definitions beyond the first paragraph definition on introduction to homicide.
That is correct. That is our
Gotcha.
position.
Okay.
And we would submit that there can be a combination of more than one negligent act that would still be insufficient to convict. And to the extent that this is implying he can have one negligent act, as long as it's clear let me stop a second.
I would say an act or acts, but the, again, when I'm going through and looking at the standard instruction, and, you know, the points you're raising, and if I'm not agreeing with it, you've preserved, obviously, and whether, you know, right now I'm continuing to follow what the current standard instructions are. You're talking here, commit an act or acts that were not merely negligent.
I think the simpler way to read, for it to read would be, George Pino cannot be guilty of manslaughter by committing acts that were merely negligent.
Okay. Well, that's kind of an interesting point, right? You know, let's say there are multiple negligent acts, okay? Does it become the case that multiple negligent acts, maybe individually in and of themselves, would not rise to the level of the type of culpable negligence that would need to be proven for there to be a manslaughter conviction? But the cumulative nature of multiple negligent acts combine to establish the level of culpability necessary to establish culpable negligence in manslaughter.
I have not seen a case that says that you add up failure to act with ordinary care, that a combination of failures rises to the level of culpable negligence. I just haven't seen that case.
I'm just, you know, this is kind of a mental exercise.
Because what we're getting back to is it one act or is it multiple acts? Is it the operation of the vessel as one act, or is it speed plus X plus Y plus Z, none of which per se rise to the level of culpable negligence?
Well, isn't that what a lot of the cases that when you're talking, the cases that you've cited?
Right.
It's that it's not, you know, there's a combination of factors that led to the conclusion, at least for that jury that was affirmed on cases, but a combination of factors that would either support or not support the verdict.
Right, in many of those cases there were multiple acts and the courts of appeals said not enough.
Okay, right.
So that the combination of multiple failures of the defendant do not combine to reach the culpability.
Depending on what you look at the totality of the circumstances, right? You have to look at the totality of the circumstances. You can't just look at it in a vacuum. Each case is very fact specific.
Right, so the combination of conduct, I suppose, is either negligent or not. And if it's negligent, then is it culpably negligent? Meaning it's not mere negligence, it's got to rise to the level of that willful, wanton, because by definition, mere negligence is not an affirmative decision one makes. It's a failure to exercise care. It's not a willful and wanton disregard. That's where we get into the higher level of, mens rea.
Mm-hmm.
Right? So I forgot my keys. I did a whole bunch of things where I was not paying attention, and I still didn't act with, mens rea. It was
again, depends on the circumstances that you place yourself in or that are created, right? So think that's the whole point of, one of the points of this case, isn't it?
So we could just go through we can do our sort of closing argument in deciding how to evaluate this, but ultimately the event that, as we've said already, the event that causes death is the elision. Anything short of that won't, as you pointed out, if he stayed on course at that speed with those life preservers, with everything else the state is focusing on, there's no death. So that's why I'm struggling with the theory that the state is advancing, and it can't be enough that the state is going to say the flares you should consider that he had expired flares on his boat in deciding whether he was acting with wantonness or willfulness in his operation of the motor vessel, that he forgot to update his flares, and you should consider that. It has nothing to do with the cause of death. Nothing. Zero. He doesn't use a kill switch. He could have been more careful. All of these arguments that the state is trying to advance, none of which contribute to the cause of death.
Okay. So where am I going on act or acts?
We propose the language. If you're going to overrule it, then it just remains the pattern.
Any comment from the state?
Well, I just want to make sure of the standard instruction after Your Honor reads the two elements of manslaughter.
Mm-hmm.
Every person has a duty to react reasonably toward others. Are we in agreement with that sentence?
Yep. No, that paragraph, I don't think that there was any dispute.
I'm just, we're talking about a lot of different things. I'm just trying to narrow down. Are we in agreement with that first sentence? If so, then let's go to the next sentence if we're in agreement on that, because otherwise we'll be here until, really late trying to get standard instructions on two relatively simple counts of manslaughter and vessel homicide.
All right. I understood then in the first paragraph, the defense believes that it should just be a merely negligent act, and then and not have anything about if the killing was either justifiable or excusable homicide, as I had previously instructed you. We agreed, I'm taking out justifiable.
Agreed.
Over defense objection, I'm going to give the best in terms of the standard. The next paragraph, to convict of manslaughter, it is not necessary for the state to prove that George Pino had an intent to cause death, only to commit an act that was not merely negligent, I'm taking out justified, or excusable, and I'm going to leave in, again, the standard or excusable, and which caused death. Okay? Go to the next page, where there's a definition of culpable negligence.
Judge, so the paragraph you just read
Yes.
begins with to convict of manslaughter. That paragraph, at least under the old instructions, made clear that that is a reference to the subsection A theory.
Correct.
Okay, so we object to that for the same reasons we object to
Correct.
the 2A theory. So we
Correct.
think that entire paragraph beginning with to convict of manslaughter, it is not necessary for the state to prove that George Pino had an intent to cause death, only an intent to commit an act that was not merely negligent, et cetera, et cetera.
Correct.
We object to that entire paragraph.
All right, very good. Let's look at the next one. Now, what the defense has requested is, do you have the defense?
Yes, Judge.
Okay. Requested that essentially I include what would be facts, or facts that the jury would have to find, in further impressing upon the jury that there has to be a showing of culpable negligence, not merely negligence. I think that that's the way I read the paragraph you want to include. Correct?
That's correct.
Okay. All right. Any comment from the state?
Yes, Your Honor. The standard jury instruction does in fact define culpable negligence. The state's proposed instruction follows that standard instruction to the letter. And I would also point out that in the Stevens versus State case at 787 Southern 2nd 747, a 2001 Florida Supreme Court case, it indicates that in order to be entitled to a special jury instruction, the defendant must prove the special instruction was supported by the evidence, that the standard instruction did not adequately cover the theory of defense, and that the special instruction was a correct statement of the law and not misleading or confusing. And I think for the defense, where they kind of fall down is that the instruction of what culpable negligence is, and the definition that it is given, is a correct statement of the law, and I don't see that what the defense has added clarifies the law. I don't think that it's necessary based on the evidence, and if anything, I think it makes the instruction a lot more complicated than it needs to be.
So,
I'm okay, but that's the rest of it after the definition of culpable negligence, right?
Yes.
The paragraph before that, where the defense is proposing that I tell the jury they must determine whether the state has proven beyond a reasonable doubt that Mr. Pino's act.
Judge, I'm going to withdraw that paragraph to
Okay.
avoid confusion. So we're withdrawing the paragraph that
Okay,
begins with the
let's
phrase
go
in
then.
this case.
Then it would be, there'd be a definition of culpable negligence, okay, which is the defense is proposing that I include the word merely negligence on sentence 1.
I see it, Your Honor.
You see it, right?
Yes.
Okay. Any comment from the state?
Yes, I don't think that it's necessary because the standard instruction indicates that if there's a violation without any conscious intention to harm, that's negligence.
Right.
Culpable negligence.
No, hold on.
I don't think that
Including the word merely. Do you have any comment on that?
Yes, I object. There's no reason to inject that into a standard instruction when the standard instruction adequately informs the jury what the law is.
Okay. All right, I understand the request. I'm going to deny the request over objection. I take the word merely out because it's not part of the standard. I think the instruction correctly defines the law. And again, I think that's for argument that the defense can make, but I'm going to instruct the jury consistent in this paragraph with what the standard is. All right, then we get to the negligent act or omission must have been committed with an utter disregard for the safety of another. Culpable negligence is consciously doing an act or following a course of conduct that the defendant knew or reasonably should have known was likely to cause death or great bodily injury. So you both agree on that. There's been no change there.
Agreed, Your Honor.
Then, now in terms of the standard, that's the conclusion of the standard. What the defense has asked, I guess as part of it would be a special instruction, would be additional language and additional definition. Okay? And you're making a reference to 8.9, which is the proof of the crime of culpable negligence. So I guess the question is, it looks like for 784.05, which is the standard is 8.9, which is you're referencing. The definition of culpable negligence seems to be a different, more expansive in the 8.9 instruction. Then 7.7 under manslaughter. Okay. So that's that first paragraph that you're asking in terms of a special instruction for me to include.
Judge, could you read the first sentence that you're referring to so I'm following along?
Okay, so you're asking me to include culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows, you know where I am now, right?
Yes.
Okay, and you're referring back to 784.05 under the standard instructions 8.9. All right, so let me ask the state. Your thoughts on that, which provides incorporates essentially 8.9 into 7.7, and under a different statute. So if you look at 784.05, all right, this is the culpable negligence, the second degree misdemeanor. And culpable negligence is a lesser included offense, category 2, lesser included offense of manslaughter. So,
Judge, the reason why what I would suggest to the court is this. If the court looks at the instruction 7.7 for manslaughter,
yes,
at the bottom it says it was last amended on September 12th of 2025.
right,
If you look at the definition of culpable negligence under Florida Statute 784.05, which is in 8.9,
yes,
it indicates that the last time it was amended was in 1985.
yes.
So I would submit to the court that the September 12th, 2025 instruction for manslaughter's culpable negligence definition is the proper one for the court to give.
Okay. I am going to give the 7.7. My question would be, though, when you look at under manslaughter, category 2 lesser.
Yes.
Okay. So category 2 lesser is culpable negligence.
However, the non-homicide lesser included offenses do not need to be given if the parties agree that causation is not in dispute and that the victim is dead. And that's from Carver v. State.
do not have to be given, right, under Carver. And it was last amended in September of 2025, right? As you said, the manslaughter instruction.
They updated it actually like a week ago. If we have the one from 72. Yeah. We know this, we have the dates on it. So we can
So I guess the question is causation an issue? And whether the defense would be seeking culpable negligence as a category 2 lesser. So I think that's the question for the defense. So I'm going to give the standard 7.7. I'm not going to, that first paragraph at least, I'm not going to give that as part of a special instruction to 7.7. The question is going to be whether or not the defense believes it's appropriate for me to give a category 2 lesser of culpable negligence, but with the caveat that, but that's a non-homicide lesser. And so we have a homicide, so
Right.
it's not applicable. I just kind of talked in a circle, but since this is a homicide, the lesser doesn't apply.
I understand the principle. This is where it gets back to the issue if the state is focusing on acts which did not cause that did not cause the death. Our view is it's the elision, not these other, like speed, for example. They're claiming speed, that he accelerated. That's the culpably negligent act. And absent the elision, there's no death. So that's the rub. I also recall that culpable negligence, I think, is a lesser included offense, that the misdemeanor is a lesser included offense of vessel homicide.
Well, we'll get to that when we get to vessel homicide. Okay. So, over objection, I'm not going to give a special on paragraph 1 in the defense request, and then there is additional explanation that you cite to the Jackson case from 1958, and also to, it's the same, okay, definition of the speed, it's about the operator drinking or not, or some degree under the influence. It's not proof of itself of culpable negligence, and the state must prove under Miller, 1954 case, that the act was not the result of a momentary lapse of memory, inattention, or mistake of judgment. Okay. All right, any response from the state?
Yes, Judge, I don't believe that those should be given.
Okay. All right. Beyond the fact that I do believe that the standard instructions are a correct statement of the law, I don't think it's appropriate, and I'm not going to give the additional language and case law citation in the jury instructions. I think that could be part of argument, if you wish to use that as part of argument. But in terms of the instructions are sufficient to define culpable negligence, so I'm not going to give what's been requested.
To make sure that I adequately explained. We weren't expecting you would put the case citations in the jury instructions.
No, I know that. You put the citations to support the additional explanatory language of what culpable negligence is, what it isn't, and to further enhance, I think that's the position of the defense, that the instruction given, the standard instruction is not sufficient.
That's right. I just wanted to make sure you knew where we sourced the language. So our request would be over, and I understand you've overruled it, that each sentence that we have submitted for as a proposed instruction be given to the jury individually and in combination or in combination with the other sentences. If there's any one sentence you think would be acceptable, we'll take it. But it sounds to me like the court is not going to give any one sentence or the combination of sentences. And so I think we've adequately preserved the objection.
Yes.
Understanding we weren't asking you to give the jury the actual case.
No, I understood that was for me to know where the language comes from.
Thank you, Judge.
And appreciate that. The standard instructions, in fact, the state had noted, but they had been amended as recently as September 12, 2025. So,
Actually, Judge, I believe they were just amended 6 days ago on June 12th.
I'm sorry, I don't hear you.
His client is saying that it appears on our computer that while we've been in trial, the rules,
June 12th. The proposed
the instructions have been amended yet again.
standard.
Yeah, that's the reasonable doubt instruction. The reasonable doubt instruction was,
All of them.
yeah.
Almost every standard instruction that I'm downloading today has been amended on June 12th, 2026. So last week.
Okay, so why don't you print out, because the only one that I have that we got a copy of is the reasonable doubt instruction with any substantive amendments that would impact our case. Is the reasonable doubt instruction, I have that as the updated instruction. I'm not sure if that was in your packet or not.
I think so.
Yeah, we have that. Thank you on that. But there were no amendments to manslaughter instruction or the other instructions. Okay. All right, so I took care of that in terms of the manslaughter instruction. Let's go ahead to the vehicular homicide instruction, okay? Excuse me, not vehicular. Vessel homicide, excuse me. All right.
Judge,
Sir?
just so that we're not confused, we understand that the instructions that we provided to the court were standard proposed instruction,
Correct.
came from the pattern instruction.
8.9.
8.9 regarding culpable negligence. It's not clear to us when it was amended. We think it was amended recently, but in any event, you have the benefit of the language that we took from what was at least at some point in time the pattern instruction. And over our objection, the court is going to deny.
Well, yes, a different subsection, which was 8.9. I understand. Okay. And Ms. Pino was not charged with culpable negligence. And that goes back to what I said, that it would be considered a category 2 lesser, but that's for non-homicide. So I don't see that it's applicable here. Okay, so let's go ahead and look at Vessel homicide. All right. All right, to prove the crime of vessel homicide, which is